now. All right, welcome everybody. Happy Thursday evening. We're glad that you're here to join us today for our webinar on immigration options for laid off workers. You know, it's been a crazy couple of months here for tech workers, especially for those who are visa holders. And so we've decided to hold this webinar today to discuss what your next steps might be and all of the available options. Albert's List is proud and happy to partner up with Ashima Dugal of Dugal Law. She is an immigration attorney who hopefully will have a lot of answers to the many questions that many of you have. This session will be recorded. We're going to have it on YouTube, hopefully by the end of the night. And without further ado, Ashima, I'm going to go over and hand it over to you. Thank you for joining us today.
Thank you so much, Albert. First of all, really appreciate you organizing this. It is very topical, and you and your community is always so helpful in providing information. Really appreciate that. I am also a follower of Albert's List myself. First, I want to share with you that I'm an immigration attorney for 18 years. I am in Silicon Valley. I've worked at large firms in the government. Now I have my own practice, and I represent startups, large employers, different industries. I also want to share that I have some insight into how, everyone is feeling. So my husband was laid off from Google on January 20th. So over the last 2 weeks, it has been, even in our house, the roller coaster of emotions, shock, confusion, anger, grief. However, he is obviously in a better position. So he doesn't have the immigration issues that all of you are facing. I decided to organize this because I am in Silicon Valley. I'm getting calls, emails, even, my own company clients. I am having meetings with them. So I just thought this would be valuable service to the community. My goals are to ease some of your anxieties and fears and give you some hope that you do have options. Okay, and I know there's a lot of confusion, so we're going to do a lot of Q&A. It is 90 minutes. I don't have too many slides. We're going to go through them because I think I'm going to answer a lot of your questions through the slides. Okay, so if you would, like to speak afterwards, I have various options, one-on-one consultations. You can book a 20 minutes. There are links here, and this is also in the chat. And 35 minutes, I have reduced fee for laid off workers to give a full assessment. All right, that's me. So I've already talked to you a little bit about my goal. I want you to focus on a short-term immigration plan. We are going to talk about short-term and long-term options because some of you were in the middle of a perm, maybe a perm is filed, no I-140, things like that. So we're going to go through all of those questions. Okay, this is the very first thing. This is critical, right? What is your grace period? USCIS's definition is your grace period begins or at the cessation of employment. That's the legal term. There are already some questions in here. The way I understand it and the way I've researched is that in California, you have a notice period, which is required by law under employment law. So this is an immigration issue. This is under employment law, labor and employment law. A lot of you were given 30 days, 60 days, 90 days. You are given a notice. And if you read that email very closely and very carefully that you received, saying we are writing to inform you that you have been notified of your termination, not that you are now terminated. So that's a different language. And so I have this saying day of termination plus 60 days. That's your grace period. So your day of termination is not the notice period. Okay, I know generally speaking, it's your last full paycheck. So there was already a question in here. Daniel Daughtry writes, the question is, the 60 days visa period are counting since the day I got the notification? Yes. I'm sorry, no, that's the day of notification, or since March 24th. So you wrote that you're on Salesforce payroll until March 24th. If you're getting full benefits, full payroll, so the Salesforce legal team is giving you notice that they're required to do under the law. So you wrote that your company lawyer told you something else, Salesforce told you something else. I'm getting these calls, and I'm sorry that's happening. That's really unfortunate, but I think you should go with your company. And I'll tell you why, because if you do have an H-1B transfer case, an H-1B portability, you're going to have a paycheck that says March 24th. And so that is going to be provided in the H-1B transfer case. So USCIS is going to be, see that, paycheck, highlight it, and they're going to count 60 days from that date. It's possible that Salesforce, immigration lawyers are going to withdraw the LCA sooner than that, are going to, withdraw the H-1B approval. However, I don't think that's really relevant when you do the transfer case. And if it does become an issue, you get an RFE. I mean, you need to get a letter from HR or send that email. I mean, you need to build the case like, hey, this is my grace period. Okay. And we're going to talk about what happens if you file the case after the grace period. Okay. So Maitri asks, February is my last day, but my last paycheck. Severance will be March 3rd. Severance is not your last paycheck. Severance is severance. So if February 1st is your last day on full-time payroll, then that's your last day. Okay. Does that make sense? You can follow up if it doesn't, but my understanding based on what you've written in your question, it would be February 1st. So there's more questions about I-140s. I think that's a later. I think I've answered all of them related to this slide. So I would request that we go, per slide, and then I will answer your questions that way. So my suggestion, if you look on the right-hand side of this slide, is that you need to have a plan of action during the 60 days, or if you have, if your grace period hasn't started yet, then you have more time to start planning and thinking, what are my options? We're going to go through the full universe of options. Okay, this is a very exhaustive, comprehensive presentation. So you're going to learn everything today about what can I possibly do. Okay, and so take notes. These are my plans, and schedule a follow-up. So I have one more question coming in. So you wrote, okay, but they will pay severance on payroll dates. Okay, so you need to look on that check on March 3rd that you receive and what it says. If it says severance, that could be an issue in the H-1B transfer. If that check says payout date March 3rd, pay period March 3rd, 0 hours, that could be an issue. So that's why I'm saying conservatively February 1st, but go ahead and just wait until March 3rd, or go talk to your employer. Go talk to HR. Like if it's not a big company, say, when you give me that severance check, don't put severance on it. Just give me a check. But if they don't have any hours, if it looks different than a normal paycheck, that could be an issue. Like they can only do so many things, right? Legally. So, okay. So anonymous, can one have paychecks from two companies if there's an overlap in the date of termination start at the new organization? I think that's a very complicated question and may not necessarily apply to what we're talking about, the grace periods, if you don't mind. So another person wrote, my employer didn't give any notice. Are they required to? I'm not an employment lawyer, but my understanding is that under the WARN, procedures, you have to receive notice, but I think you need to speak to an employment lawyer. If you want, you can, email me after the call, and I can refer you to a local employment lawyer that I know who's very good, a small firm, and you can ask her. Okay. So in your announcement letter, it is written like this. So does my grace period is March 20th. So again, in your announcement letter, if it says on this day, we are notifying you of your termination, then that's the notice period. And if they say your last day of employment on payroll will be March 20th, then you start from March 20th. You start counting the grace period, okay? Okay, so Abhi writes, so this is another law firm, said my last day of service of active duties is beginning of grace period. Okay. Even though my last paycheck is 3 months away. So again, you need to look at the notice. When you say that your company lawyer told you this, I think you need to look at, again, what does that letter say on it? Does it say you are being notified of your termination today? So Abhi, do you have that email or letter from your employer? Not from the company lawyer, but from your employer, your company where you worked. So, and then if your last paycheck is 3 months, so that means you were given a notice period of 3 months, is that right? Okay. So Shivank writes notification period. Okay. So Shivank writes January 18th through March 20th, you are not expected to report or to perform at Amazon. Okay. Great. If you accept another role before, you are not eligible for severance. Okay, that makes sense to me. If you have not found a job, your employment will end on March 30th and you will be eligible to receive a severance. Okay, so it doesn't seem like there's a question in there, but you are in the notification period. March 20th would be when your grace period begins. So going back to Abhi, they're focusing on the Department of Labor rules on remaining in active, productive employment for H-1B workers. That is a requirement. However, the grace period rule is a Department of Homeland Security rule. So the no benching provision must remain in active employment is a Department of Labor rule. Well, who is enforcing your grace period? It's USCIS. It's Department of Homeland Security. And it's defined as cessation of employment. So it gets pretty complex. I really wish USCIS would come out with some information, some guidance on this, some clarity. But it is very situational. They haven't published anything so far. So I think that it seems like I disagree with what a large law firm has informed you. If you want, you can go back to them and don't mention my name, but just say, my understanding is that it's cessation of employment. I'm still employed. There's a notice period. Could you please clarify, or go back to if you have any contacts at your company? Okay. So I'm going to move on because I know this slide takes a lot of time. I know that because I've been talking to a lot of people and there's a lot of confusion, but there's a lot to get through. So thank you for asking really good questions though. Can you travel now while you are employed in the notice period? Yes. If you re-enter and CBP says, oh, you work at Google, so you weren't laid off, your legally correct answer is, I am currently still employed, which you are. But if you travel during your grace period, you've already been terminated. So don't do it. If you travel, you cannot return on that H-1B visa or L or TN or whatever it is, connected to that company. So any questions about travel? So we're going to ask questions slide by slide. Okay, so no questions about this slide. All right. So this is a really important slide. H-1B portability. I'm assuming a lot of you are on H-1B visas or H-1B status. So port is the same thing as transfer. Okay, H-1B transfer, H-1B port. So filing, means submission. Okay, submission of your H-1B petition to transfer within the 60-day grace period. That's perfect, right? Wonderful. But you got to plan it. So you have 60 days. So you can't get a job offer on day 58 and turn around and file it. That's not possible, because step one of every H-1B petition is the labor condition application, which is by Department of Labor, and they're taking 10 days. So you've got to plan it. I would say by day 40, day 45 of your grace period, you have to start thinking, what are my options now? I don't have a job offer. And so day 45, 10 days, day 55, you can file. You can still file. There is Memorial Weekend, like if you're a, Zoogler, there's some holidays in between. So any questions about filing within the 60-day grace period? And when I say filing, I prefer to file on day 55, because FedEx next day, and in the recent past, even in the Bay Area, there was so much flooding, FedEx couldn't deliver. So you wanted to reach there on day 59 or earlier. Okay, I see some people are raising their hand. I think it would be better to put it in the okay, thank you, put it in the chat, or in the Q&A, excuse me. It's calendar days. So Gauri is asking, is it 60 calendar days or working days, not business days? It's, Gauri, it's calendar days. Okay. So what happens after the 60-day grace period? You've all heard already that USCIS has discretion. I did file a case, in late December, for a laid off employee, and it was approved. And my argument was the holidays, it took a little longer, DOL, maybe wasn't working, et cetera, et cetera. And so that was great. Now, let's say it's day 62, 63, 64. I think the chances of them approving both the extension and the petition are high. But obviously, I can't guarantee. I don't know what they're going to do. It's case by case. Now, every H-1B petition has two parts to it. The H-1B petition is one, which is, your eligibility, what is your degree, what is the role, the company. And then there's the I-94 part of it, which is your status. And you are applying for an extension of status of however time is left. So when we say that your H-1B may not, be approved, we're talking about the extension of status. So USCIS may deny the extension, but still approve the petition, okay? And they might approve it for consular notification. That doesn't mean that you have to return home to Mumbai or London or, Paris or wherever. It just means that you do have to depart and get back in I-94 status. The terms in which you can depart and not have to get a new visa stamp is one, your I-94, is valid and your H-1B visa is still valid. If your H-1B visa is expired and you file after the grace period and the extension is denied, then you cannot, for example, go to Puerto Rico or Mexico for a week, go on vacation and re-enter and get another I-94, because you can't re-enter because you don't have a valid H-1B visa. Okay. Okay, so this is a very situational question. I'm going to come back to that at the end, if you don't mind. Well, okay, so you write, let me just see if I can answer it quickly. I can travel, correct. I don't know. I need more information. I'm so sorry. Somebody anonymously is asking about when can they travel, and they've given dates. So there's more questions coming in. Okay, so this is actually a very good question. Somebody anonymously is asking, my company lawyer mentioned I can stay in the US after the 60 days. I will be out of status, but I can stay and continue to job hunt as long as my I-94 date is current. They won't accrue unlawful presence. Condition you have to re-enter. Hard to believe, I want to confirm. So I'm not going to encourage you to stay beyond the grace period, okay? I think the safer thing to do is file the change of status to a B visitor or H4 or L2, like a dependent visa or something. So it's indicative to USCIS that you're taking proactive action to maintain your status. However, what is the consequence? If you don't do anything and it's day 62, you get the job offer, it's day 72 now because the LCA takes 10 days, and you file that H-1B transfer. Again, this is the consequence. I just mentioned it to you. The extension may not be approved. The H-1B petition is approved. If you have a valid visa, you depart. You don't have to go home and get a new visa stamp. You could go to Mexico or Puerto Rico. I say Puerto Rico because Indian passport holders can go to Puerto Rico without, I meant Jamaica, sorry, not Puerto Rico. Puerto Rico is US territory, so you have to go to Jamaica. And you can enter Jamaica without a Jamaican visa. So again, I don't think you should rely on that. Oh, well, I'll just go abroad and come back and get new I-94, because we don't really know the long-term consequences. No attorney does. Will they say, well, you stayed, your I-94 is valid until June. Your last day of employment was, February 15th, and you stayed 3 months extra. So at the time of the green card stage, at the time of, maybe porting or anything, could this come up? Certainly, it certainly can. So you want to be conservative. Okay, I mean, I'm giving you that situation where it's like a couple of days after your grace. Okay, and you can argue, well, the H-1B petition was about to be filed any day, so I didn't file that change of status to a B, So I know there are a lot of questions. I'm just taking questions on this slide, so we cannot talk about different roles. Somebody's asking about changing status. There's a whole slide on that. We are going to talk about, Nishant, we're going to talk about your situations and scenario. I'm going to read you this question. Company informed of termination on February 1st. So that was the notice date. Will run payroll till, April 15th. So that's a good long period. Last paycheck would come on April 31st, and they would inform USCIS of the last day of employment being April 15th on May 15th for H-1B revocation. What date is the grace period start? Company lawyers are asking me to be conservative and treat February as a grace period. Again, we've covered this. Your notice date is February 1st. So you're getting full pay and benefits, looks like until April 15th. So I would count that as April 15th. Okay, because first of all, your company isn't filing that, revocation or withdrawal until much later, right? So USCIS isn't being notified on February 1st of the termination because you aren't terminated yet. You're in a notice period. So that's my analysis. I mean, you're welcome to, go back to your company lawyers or your company itself ask them to verify, but that is my analysis and I'm sticking to it. Okay. By the way, I did also speak with an employment lawyer about this situation. And so I think that this is a question of employment law and not necessarily immigration law. Certainly the grace period is a question of immigration law, but the grace period begins at the cessation of employment. So that's an employment law matter, okay? Okay, so we're talking, people are asking about married and US citizens, so we're going to talk about that later. How do you check your I-94 dates? That's a really good question. You can just search. Search terms are Customs and Border Protection, which is CBP, get my I-94. That's it. It'll come up, and then there'll be different tabs, and you just go to the tab that says get my I-94. So obviously that's important, because that's when you start accruing unlawful presence after I-94 ends. And also that's important because if you have a short I-94, the person who asked that question about April 15th, what if, the I-94 expires April 1st? Well, that means that April 1st is when her grace period ends. It's not April 15th. So an earlier slide I had was your grace period is 60 days after termination or when your I-94 expires, whichever is shorter. Okay, so everyone does need to check their I-94. All right. I think we've covered this slide. So, a lot of you, I'm assuming, have worked with a large employer or a mid-sized employer, and it was a single petition and that was your full-time role. Well, you're heading into obviously a job market that there are a lot of layoffs, obviously, but people are hiring. There are more job openings. People are hiring. So how do you make yourself attractive in a short amount of time? So I'm just giving you some ideas here. You can work for multiple employers. You can work for one employer part-time. So the immigration regulations don't say that you have to work, 35 hours minimum full-time. So, and there's no minimum actually. I wouldn't, I have filed cases for 15 hours. I think 5 hours is a little low in my opinion. A range is beneficial. So the employer lists, how many hours are you going to need this individual? They could say 10 to 20, and so that gives them a little flexibility. They have to pay you minimum for 10 hours. Okay. You can also take short-term projects. So rather than a 3-year H-1B, it might be a 1-year H-1B. Or it's still 3 years, but the at-will employment relationship is just 6 months. So what is a concurrent employment? When you have one approved petition already with one employer, and whether it's part-time or full-time, you can actually get second jobs at different companies for 10 hours or 20 hours or what have you. It can be in different fields, certainly. And but for each company, you have to be a W-2 employee versus a contractor. An independent contractor is a W-9 employee. Okay, W-2 employee means you're a salaried employee with generally you can be hourly, so it doesn't have to be like an annual salary. Okay. So I'm going to just go through the questions. So I am taking questions based on slides. So great. So somebody asked, can I work on full-time role plus part-time? Yes. I generally don't think working 2 full-time jobs is a good idea, but that can look a little, interesting to USCIS. But you can work what you're describing. And so somebody else is asking, how safe is the contract-based consultancy work on H-1B? I mean, you'll be at a client site, I'm assuming. So those cases tend to get, more RFEs, but they are approvable depending on the facts. I think I would need a lot more detail to answer your question, how safe are they? But I think that is more of a one-on-one conversation, but just make sure that if it's like an IT consulting company that you don't get benched. Like, sometimes what happens is they hire you for a particular project and then that project goes away or it's very short. They don't have new work for you. And so you're just waiting. So that is a period of inactive employment. So that is different. That is different than the situation of a notice period. Okay. Why is it different? Because a notice period is a notice of termination. It's not like, they don't have any work for you. And so they're benching you. Those are different facts. So that is why I think it's perfectly fine to have a notice period when you are not working, and you can still be, employee of a particular company on payroll, etc. Okay, so I'm just going to confirm we've answered the questions related to this slide. Okay, so Nishant, you're asking a lot of like specific questions. I do recommend you schedule a one-on-one because I want to see it. I want to see the documents. I don't want to give you legal advice without seeing your documents, okay? Because you're saying you checked on CBP's website. You're asking about your I-94 and travel. So you can schedule with me. You can schedule with another attorney. Okay. So let's keep moving. So I just put this slide up here to give you an idea. So most of you are level 2 or level 3, maybe level 4, depending on the position. So your prevailing wage, these are prevailing wages in the Bay Area, is determined by the position. The position is a senior level position, but it's also reflective of, how many years of experience you have. I mean, if you're 20 years experience, obviously you can't be level 1. Level 1 is an entry level position. So this is the Bay Area, but for software developer. There are different kinds of, even within the software development field, there are different kinds of titles and positions. So don't assume that you fall in this category, okay? So any questions about prevailing wages? Like, so if they pay you hourly, this is how much they're going to have to pay you if you fall in this category of software developer. So Maxwell is asking, who incurs the cost? The employer by the Department of Labor regulations. Daniel, we have several slides on self-employment. Let's talk about that. We're going to get there pretty soon. Okay, I think I've covered everything related to this slide. Okay, if my slides don't cover, we are going to hang around and answer your questions, so don't worry. Or you have to schedule an appointment. So I did see somebody asking about this, about EADs. Oops, excuse me. Oh. Okay, so yes, you can work on an EAD. That's basically it. I think, though, it is advisable that you maintain some non-immigrant status, whether it's an H-1B or L or what have you. Any questions about this particular slide or scenario? Someone is asking, how do we schedule an appointment? At the very end, I'll put it up there again. I mean, you can just go to my website. There's a calendar actually on my website, Google Law. So somebody else is asking about a prevailing wage. If my former company was paying you level 3, but now you're making level 2 or you have a level 2 offer, I think that's okay, because it really depends on the role, right? If it's a senior level role or a manager, you're a director, that's going to be a higher wage, prevailing wage. Okay, great. Some of you may decide you want to go home and visit your family, and you'll look remotely for work, and that's perfectly fine. A lot of interviews, you don't have to go in person. So if you choose to leave the US during the grace period, can you come back on your existing H-1B? If you have time left on your H-1B, the 6 years, it could be more than 6 years if you have an I-140 approved, then yes, you absolutely can. You do not have to go through the lottery again, okay? You can also recapture that out of country time. So any questions about this particular situation? Okay. Do we need to talk about TN? Anybody on a TN visa on this call? You can raise your hand if we want to talk about TNs. TNs are for Mexican and Canadian nationals. All right, so we're going to skip it. Yes? Should we go ahead and skip it? Okay. O1, anybody on an O1 visa? Raise your hand or write a question. 2 participants. Okay, great. Again, you also, it's very similar. You do have a grace period, just like the H-1B. And again, you do need to look up your I-94 card. So during your grace period, and even today, even now, if you haven't entered your grace period, you can look for positions. You have to stay within your field, whatever that O1A was approved as previously. If you want to change fields, you know, you're gonna do a whole new O1A. What I love doing O1A visas, you can actually start your own company. You can work for multiple entities. So if you are on an O1A working for a single employer, then that is considered like a single petitioner. So if you look on the right-hand column, it says transfers. Well, it's a tough job market. So let's just say you want to be a consultant. And by the way, unlike the H-1B, you can be a consultant, a contractor. You don't have to be a W-2 employee. So you have a lot more flexibility in finding work. So who can be an agent? US citizens or US companies. So a new company, let's just say, wants to hire you, but you want more flexibility and control. So you could, you know, have a colleague or somebody you know, maybe a family member, serve as your US agent, and they are the signatory on your petition. And then you have contract agreements with different entities, or maybe one entity, all within your field, to serve as their advisor, consultant, CEO, you know, fractional CTO, whatever it is. And so the agent is like a hub, just like, you know, in Hollywood, they have agents. So O1As can have agents, and then you can work at multiple entities. You know, we can do an O1 pretty fast, especially since you already have an O1. So you do have enough time, but if you're nearing the end of your grace, you want to, and you don't have a job offer, then again, you might want to consider changing status to something else and then continuing to look for work. Can you start your own company on an O1A? Absolutely. And I have lots of clients who are founders. All right, so any questions about the O1A? People are asking about H-1Bs. There were a couple of people who are on O1As, so do you have any questions about O1As? Okay, let's move on. E3 and H-1B1, do we need to talk about that? Please raise your hands. Nope. Okay. L1s, I'm sure there are some L1s. And yes, 3 participants have raised your hands. Okay, so you also have a grace period of 60 days. Same thing. When does your grace period begin? Notice of termination does not count. It's the actual day of termination. You know, L1s, it is more restrictive. You have to stay within the group of companies. Just an example. If you know, are an employee of Google, you've been terminated, then if you have a copy of that blanket approval notice, then you need to look on there and say, what are the group of companies? You know, maybe you can work at Nest or YouTube or Google Ventures, or, you know, one of those companies that is related. You have to be legally related. The H-1B lottery is coming up in March. So if you want to try to get out of your L1 status and you have a job offer from, you know, a company outside of that group, you can apply. Any time an H is counted against your L, vice versa. So if you're, at 5 years on an L, then you're only going to get 1 year on an H-1B. But maybe if you have an I-140 approved, then you can extend beyond the 6 years. Okay, any questions about the L visa? So somebody is asking about, they have an L-1B visa and have a valid approved H-1B petition from the same employer, which was never activated. Okay, so you never entered H-1B status, I'm guessing. And do change of status. I think you should be able to, but I would, want to learn more facts. So they're asking, can I transfer my H-1B petition to a new employer and do a change of status during notice? I don't know if you'll be able to do a change of status, because if you never entered H-1B status, your current status is L-1B. So you're changing to, so you're filing a new H-1B petition, change of status. If you never entered H-1B, I'm not sure. I think you might have to do consular notification, but it's possible. So I do think you should, contact me or a lawyer to ask that question again. So it says, somebody asked, I'm in an L-1A visa with I-94 till 2024. I have an approved EAD, but no AP if my company lays me off. Am I bound to find a job within a certain grace period? Or I can try to find job till EAD expiration date. So if your EAD AP, I'm assuming is through your company, the EB1C multinational manager petition, then it becomes a little complicated, because you have filed for a green card, but you don't have the green card yet. I believe that when your grace period ends, your I-485 may not be valid anymore, because you have not actually, it's related to your company. In other words, I don't think it's portable, but if you don't mind, just email me. I'll just, look that up. But if you're, I need to know what is the basis of your green card, basically. If it was EB1C, it is a little more complicated. So somebody's asking about self-employment and H-1B. We're going to talk about that. Somebody else is asking about, on an L-1A, you received your green card EAD, but I-140 is pending approval. Can I transfer employer based on EAD? I don't think so. But again, I do think these are very unique situations. So please talk to somebody, but I don't think you can, because if your green card was based on the EB1C multinational manager petition, you're no longer with that company. That's the issue. Okay. So Anonymous has asked a question. I think we've covered that sufficiently. I've been in H-1B for 10 years. I-140 approved. Can you go home? Yes. Yes, you can enter on an H-1B for the remaining time. So no other questions about L1s. Let's keep going. Self-employment. So I think we're doing, let's just do a little time check. Okay, I think we're doing good. We are going to get through everyone's questions. And if it's 6:30 and we don't, then please, contact me. If you just go to my website, dougallaw.com, there's a calendar. So I can spend more time with you, look at your documents. I think that is better than just giving you a quick answer, okay? Unless it's a very general question. So all of have heard that you can't really, have self-employment. You can't have your own startup and be 100% owner. That's true. However, you can, join forces with others, whether they're laid off or US citizens, permanent residents, maybe they're on an E2 or an O1. And you can have your own startup. I represent these individuals, frequently. It has to be a real venture. You can't just do this for the sake of a visa. Okay, I'm never going to advise you to do anything illegal. You should not do that. So when I say it has to be a real venture, you have to be actively working towards developing a product, a service, providing a service. You should, do all of the necessary steps that one does to have, a company, which is you register with the Secretary of State, you build a website, maybe if it's, if you're in the software field, you have a prototype, you're actively working towards this. If you are on an H-1B, you should not own more than 50% of the company. So, maybe there's 3 or 4 of you and you divide that up however you think is fair for you and you've negotiated. The thing is, though, that you have to be an employee of that company. So that means you can't really be like, even if they called you the CEO, then you need a separate board, okay, who controls and supervises your work. If it's a little easier if you're not the CEO, right? Because then you don't necessarily need a board and like a lengthy employer-employee agreement if you're a software developer. And there's a CTO who is a US citizen. That is a less complex case. But these are more complex cases. They require careful strategies. You do have to, make prevailing wage. You do not have to work full time. So if you want to pursue this path, and I was just speaking to a foreign national today, and we were just going through different options, and I just said, well, do you have any ambitions to be a founder? And he's like, yes, I would love to, have my own, company for these services that I've been doing for large companies. And I said, well, you can do it. And so he wasn't aware that was a choice. And so that was a really exciting moment in our call. Gauri is asking, does a training coaching for the H-1B firm? So you're basically offering those services, which does training coaching for programming and interviews. Well, it has to be a specialty occupation, your role. If you're on an H-1B, it has to be a specialty occupation. If for example, if it's a coding school, if you're doing coaching for software development, that will, if you're some sort of teacher related to that field, that would be okay. But I think what you're, describing is training coaching interviews. So I don't think that, based on what the facts, I think that would be a difficult case because you have to show that the H-1B position is a specialty occupation, which means it's a professional position, one that would normally require a degree. So for example, USCIS usually, like if it's a marketing analyst or marketing manager or account managers, those are more difficult cases. So any questions about this, starting your company? Okay, somebody is asking, can I start a company along with other H-1B visa holders so that none of us own more than 50% or a US citizen has a majority? Yes, I think that's the exact example I gave. Absolutely. None of you own more than 50%, US citizen. I mean, I don't think the US citizen necessarily has to be the majority stakeholder. I think you need to figure out those terms amongst yourself, and then talk to an attorney. Like if it's 3 of you, 33%, seems logical. But again, it depends on if somebody is investing more, right? That's different. Now you have to show the ability to pay the H-1B worker. So I have had clients get angel investors. Angel investors in the startup community are usually friends and family, right? They're usually not a big VC firm. So let's see. I think I've answered questions related to this slide, and we can, discuss your other questions as we proceed. All right. Should we talk about the E2 visa? I think we should, actually, even if you're not on an E2, because this is an option for self-employment. Canadians, Mexicans, most of Europe. So is anybody interested in an E2 visa? I just want to see how much detail we go into it. Okay, so I'm just going to throw out some examples. I've done cases for 40,000 investment for an e-commerce shop. I've done cases for $500,000 investment for an investment banking firm. It really, the investment has to be proportional. If you read online, everyone says investment must be substantial. You shouldn't try it for less than 100,000. I disagree. I have done cases for less. It has to make sense, basically. What does proportional mean? It has to make sense to the business. So what is a normal investment for an e-commerce shop? You don't need to invest 1 million. I mean, maybe if you're, competing with Amazon, maybe yes, but if it's like, a business making onesies for kids, that's your inventory is going to be less, your investment is going to be less. And so you do need a business plan. I would start early if this is a route you want to go. It does take time to build this case, but I can do it pretty quickly. I love E2 cases. So people are asking, I bought a house in California. Does this qualify? No, it cannot be a passive investment. Daniel, it has to be an active business. I mean, if you're going to even if you're going to rent it out, that still doesn't count, because what are you actively doing? I mean, it may or may not count. If it's like a bed and breakfast where you're actively managing, it and doing advertising and cooking and cleaning, maybe that would count. But it also has to not be marginal, okay, which is another legal term. The business cannot be marginal, which means that the anticipated returns, the profits on the business, are higher than your necessary living expenses, okay? So if you, have a small house that you're gonna convert into an Airbnb or a hotel or bed and breakfast, what are your projections? If it's just, 1 bedroom you're renting, that's not going to be enough to meet the marginality requirement. Does the company, so, Daniel, I mean, if you're really thinking about this, I do have some clients who just purchase an existing business. There are lots of businesses for sale. And so, I have, there are brokers you can work with. So you do have a lot of options if you're doing an E2. It can be a brand new business, certainly. So Maxwell is asking, does the E2 have to be STEM-based? No, it can be anything. One of my favorite E2 cases 2 years ago was a big tech employee and his wife and their friends who friends are, have experienced training horses and alpacas. They started an alpaca farm. So that was really fun case. And they're doing, weddings there. They're going to sell, wool and alpaca wool and lavender. It was really, really interesting. And it's a completely different way of life, than the Bay Area tech scene. Obviously, they moved out of the Bay Area. They moved to a state where they could purchase several acres of land. So it was very interesting. So, I mean, really, you can do anything that you're passionate about. Doesn't have to be like, if you're a software developer, it doesn't have to be in software development. But you have to show some nexus, like if you have no experience in farming, right? Let's talk about it. Like if you have an E2 case, how do we make it work? Daniel, you said it's 4-bedroom, 2-bath. I think you really should consult, how are you going to turn this house into a business? So I think you need to talk about that. Okay. Like if you're going to run a at-home preschool, that's different. That would work. If you're going to, rent it to another preschool, that's doable. Okay. So let's keep moving. So I just wanted to tell you the differences between the O1A and the EB1A. If you do qualify for an O1A or you have an O1A already, can you qualify for a green card through the EB1A? Potentially. It's not a guarantee. Just because you have an O1A doesn't mean you automatically will be eligible for the green card. The EB1A has additional requirements. So the O1A and the EB1A, you just have to meet 3 of these, 8, the bullets, or I think there are 10 bullets. But the EB1A, you have additional criteria you have to meet. EB1As do have a lot of scrutiny. I do cases for entrepreneurs, for scientists, for artists, EB1As and O1As. So, but it is the first preference category. So I do have Indian clients who are in tech, who are stuck in EB2, right? Perm, long priority dates. We do an evaluation, and we find that, okay, they have 2 or 3 criteria they can meet. They have been working for 15 years in leadership roles. So we can potentially meet, the final merits analysis of an EB1A, which is, sustained acclaim over time. And then over the next 6 months to a year, we build their case together. I had a client who met 5 criteria, but 2 of them were like on the weaker side. In the 3 months he was my client, he published. He had, he already had some papers and presentations at journals. I'm sorry, at conferences. So he converted those into papers and published them in journals. He went out and sought memberships in associations. He had a lot of speaking engagements. So, and we won that case, no RFE, but it was built over time. Okay. So somebody is asking, you said, what if the client has been affected by layoffs? So the O1A, if you qualify for an O1A, you should do that during the layoff, during the grace period. It is an option for you. If you're an H-1B, can't get a job, you don't want to deal with the prevailing wage, you want to be CEO, do an O1A. You can start your own business on an O1A. Okay. The green card, I'm just telling you as an option. You lost your perm, you were terminated, but you have an I-140 priority date. That's going to be current soon, but you have no job offer. You have to get back into that same or similar prior occupation, but you're not able to find a job. The EB1A, you can self-petition. So that's why I'm telling you about that option. All right. We're going to stay on this slide for a couple of minutes because this is, all of you have been asking about this slide. So now we're talking about what happens if you cannot find a job. You're on day 55, okay, day 50. Certainly, if you have a spouse who has an H-1B, you can change to their H-4 or an L-1. You can basically become a dependent. You can also change to B-1 or B-2 visa. And then that buys you some time. That buys you 180 days. And you can continue looking for a job. When you file a change of status, you cannot travel. Okay, I want to make that clear. You have to remain in the country. If you do travel, that case is automatically considered, abandoned, and it will be denied, that change of status. You will not be able to re-enter in an H-1B or L-1 because you're outside your grace period. Okay, so I want to make that clear. So on the left-hand side, you have that one box. If you find new employment while still in your 60-day grace period, that's great. But you already filed an H-4. So in that situation, let's just say you decided on day 40 to file a change of status to a B1, okay? But then on day 45, you get a job offer, they start the LCA, great. So when you file that change of status, because you're already doing, already have the B1 pending. So you would then, you can go ahead and, begin employment, and in H-1B when it's approved, and then you can withdraw that B1 or H-4, whatever that change of status is. So there's no issue there. They should approve the change of status. They should approve it. It won't be consular notification. However, if you find the new employment after the 60 days is over, so in that situation, day 45, you file that change of status to H4 or B1 or whatever it is. And then after the 60 days is over, you find the job offer, it's day 70 now. So they're going to file an H-1B. So I don't know what USCIS is going to do for sure. It's discretionary. However, because you filed that change of status, they're likely to approve both the petition and the extension, because they have seen that you attempted to maintain your status by filing that change of status. You may get an RFE because USCIS will see that you've filed a B1 or an H4, and then later you filed an H1B. So when you file that H1B, you might get an RFE, and they're going to ask, well, what do you want? What is your intent? And so then you can just say, I'd like to withdraw that case. A lot of these things are unique and different. It depends on when your I-94 is expiring, what kind of status change you requested, when it was done, when your visa is expiring. So I can't give you like a general rule about what will happen. Okay, so, but I think you just need to engage with counsel and, at various times throughout this process. Okay. So any questions about this topic? I'm surprised there aren't a million questions about this, because this is very, confusing. No questions. Okay, great. Oh, okay, so somebody is asking, okay, there we are. So Rajit writes, what is the process for change of status to H-1B when change of status on other visas pending? So I think that is basically the slide. So it really depends on when you filed that, H-1B. If it was within the grace period, but the B2, H4, F2 is pending, I think you're going to be in good shape. You're going to have the change of status approved. You can withdraw that, intermediary H4, B2, F2. If you filed that H-1B after the grace period ends, then it's a little more complicated. Maybe it'll be approved for consular notification. Maybe they will just approve the extension. Okay. So somebody else asked, can L2 visa holder work during grace period of L1 visa holder? My understanding is yes, until the end of the grace period. Okay. How much time does it take for change of status from H-1B to be? Okay, so you can request 180 days. The B1, B2 is, there's no premium processing for a change of status to B1, B2. So you have to, put it on your calendar, because it's only valid for 180 days. So you have to either file that H-1B transfer within that 180-day period, or you have to depart. Some people just file multiple B1s. I don't really recommend that under these facts, because USCIS has given you a grace period in which to take action, and you took action. Maybe the reasoning is I have to sell my house, or my kids are in school. I need more time to wrap up my affair, so I'm going to change to a visitor, whether it's a tourist, or a business visitor. And then you file another one, and then like 12 months later, you find that job. I think that's going to be suspicious. I wouldn't recommend that. So I think this just gets you a little bit more time, 3 months, 4 months, 5 months. Now, note that if that B1, B2 change of status is denied, then, and your I-94 is still valid from the H-1B, but that B1, B2 is denied, you're immediately out of status and you start accruing unlawful presence. So you have to be careful of this strategy. You have to have a reason. I like documentation. What is your reason for the B1, B2? We are going to go through a slide about this B1, B2, okay? So somebody writes, if I had an L1A visa and my spouse is unemployed, do I have the option of changing my status to B1? And yes, okay. If my spouse is a green card holder, what visa status should I transfer to get more days? if your spouse is a green card holder, I mean, can you just apply for a green card through them? Maybe that's an option. I think you should, you know, if you're married and they have a green card, maybe you can apply for a green card, possibly. So will withdrawal happen after change of status to H-1B is approved? Okay, I think this is the exact slide. So I'm going to not answer that because I have answered it a few times. Should we be targeting change of status application on 30th day of grace period? That's a good question. Can kids attend school when change of status from H1 to B? So under the US Constitution, a child can go to public school, whether they're in B1 or H1B. USCIS generally doesn't want, you know, if you enter on a B1 visa, the US, they don't want you to enroll your kids in school. That's, you know, the B1, B2 is not for that purpose. However, in this case, you're changing status. Facts are different. I think they can continue because that B1, B2 is pending. You haven't entered B1, B2 status. You've only applied to change your status. Okay, now when should you target it? I mean, if you have no leads, no interviews, yeah, I mean, if you just want peace of mind, you can do it on the 30th, you can do it on day 45. I think that a conservative approach is start thinking about it on day 40, engage with the lawyer. I mean, yeah, you could probably do this yourself, the B1, B2. However, the stakes are high. You want it to be perfect, accurate, timely, you know, make sure you have the right filing fee, you send it to the right place, all of that. Attorney's not going to charge you too much for just a B2 change of status. And I think there's a strategy too. If you were just here, you know, for medical reasons, and it was an extension and you have extensive documentation that you have cancer and you're here for, you know, that's not a difficult case. But here we have to figure out what is your reason and document it. You have to have a reason, okay? So I think this is, I'm going to skip over some of these questions because they're not totally relevant to this slide. Okay, so Nishant is asking, once I apply for B2 change of status, which I believe is online, how long does it take to get approved? It takes a long time. Does the 60-day clock stop right after I submit? No, you still are in the grace period. So they take more than 6 months to get approved. Okay, so you have to put it on your calendar, 180 days. You can't be here more than 180 days, even if it's pending. So because the approval is going to take longer than 180 days. Okay. So yes, I think somebody is asking about my fiance and I were supposed to get married this year. If we expedite the marriage, is 60 days enough to get court marriage done in California? So in Santa Clara County, which is where I am, yeah, you can, I think it takes a week. You can get that marriage certificate. It's better that you provide some bona fides and get a, medical exam, and all of that can be done. I have a slide on this, so we can go to that. And then you can apply, once you have the marriage certificate, certainly you can apply from to H4 status. Yes. I'm sorry, you don't need a medical exam. I thought you were marrying a US citizen, excuse me. You don't need bona fides. You just need a marriage certificate if you're going from H1 to H4. This one is not about change of status. So Venkata says, yes, you can. Would it be quicker? I mean, so Venkata is asking, can I leave the country during my H1B grace period, make an H4 interview appointment, and come back on an H4 visa? Is this going to be a quicker, or staying in the US and applying to change of status? So, you have to check the times, and let's assume you're going to the US consulate in Mumbai. I believe the current times for an H1B is 80 days. I don't know what it is for an H4. I haven't checked recently. So if it's 80 days for an H1B, I'm guessing an H4 is longer. I'm guessing. So you have to check the visa wait times. And then of course, the benefit is you get to stay here versus traveling, getting the visa, re-entering. If you just file a change of status in the US, it's probably going to take longer to get that approved, certainly. If you're trying to get an EAD, you know, then maybe it is faster to go to India. So it's very, very fact oriented. Okay. So somebody's asking, anonymous, when does the 180 days start for the B status? Upon filing, you get that receipt. So it's 180 days. Okay. Rajat is asking, is 180 days clock only valid for B1, B2? I don't think it applies to the F2. No, you're asking about an F2. Okay, so I think did I answer all of your questions related to this slide? I think so. Okay, let's go. Let's keep going because we have approximately 15 minutes left. I'm going to tell you a lot more information. This is the F1 slide. So if you have been terminated, you should, you know, notify your school officials about this. Do we need to talk about this slide, the F1? I think you have to go mostly through your school, okay? But you're in a better position, you know, you're OPT, you can more easily find a job. Okay, this is what I really, you know, want to talk about, these two slides, the B1 temporary business visitor. So if you are wanting to, you know, there were a lot of questions about starting your own company. This is the visa, it's the B1. The B2 is the tourist visa. So this is straight from USCIS, these bullets. So let's say there's a conference you really want to go to. There's an AI conference coming up. There's a, you know, business and marketing. There's, you know, tech conferences of various natures. So you actually register for them, pay for them, and go to them. Okay, and that's your reason for changing your status. Maybe there's a particular training program you're looking into. Now, if you are setting up operations, whether you want to pursue an E2 or an O1 or an H1, then you can, you know, talk to VCs, you can have meetings. There's a lot, you know, if you're local or in California or Seattle, you can do a lot here. So I'm seeing some hands going up. Do we have questions about this slide, the B1? Yep. Any questions about this slide? Oops. B1. Okay, let's go on to B2. So I do think that if you want to you know, pursue the B1, then you need a strategy, you need documentation. I think the B2, you also need documentation. You know, are you going to a wedding? Are you going to a reunion of some kind? What are you doing by needing to stay longer? And it is fine to say wrapping up personal affairs, certainly. But, you know, I just want you to know that 4 months later, you file that H-1B. That H-1B may get an RFE, that H-1B may, you know, the extension may not get approved. They're going to look at your B2. They're going to say, okay, well, it says here you were wrapping up affairs, but you know, how long does it take? You don't own a house. It's been 4 months. You know, so I just think you need to document. There is a personal statement you should be completing for this. So again, I don't think you need to be overly cautious. I think this is a good alternative for you, but I think you need to develop that strategy and have preferably some documentation. If you have one B2 change of status from H-1B in your grace period, I think that's okay. Just don't do it multiple times for years. I don't think that's a good idea. Switching to yeah, H4, that's a definite alternative. H4, L2, TD, Do we need to talk about this slide, or should we go more to questions? Anybody want to raise their hands if you have questions about becoming a dependent on your spouse, spousal visa? Okay. So marriage to United States citizen or permanent resident, you can do that. You can file the case in the grace period. It is enough time. So these are I just threw up some evidence, kinds of evidence. I mean, certainly you need a marriage certificate, obviously, but in addition, commingling of financial resources is necessary, and you have to reside together. So if you're in different states, you're probably going to get an RFE, okay, if you don't have the same address. These are just, other sponsorship options by other family members. I just threw that up there. It's not necessarily like fast, but I just wanted to let you know that you can get sponsored by your brother and sister, etc. National interest waiver. I mean, some of you, if you have, like, if you're in a particular kind of startup where you're joining it, and maybe your your prior roles have been in a particular field that the US might be very interested in, whether it's climates or GPS navigation. If you're in a science field, if you're in biotech, I think you could potentially have a good NIW case. You have to have an advanced degree, like a master's or higher, or bachelor's degree and 5 years experience, which I'm assuming a lot of you do have. What's great about the NIW is that you don't have to do the perm again. You don't need an employer. This is a self-petition. Okay. Lots of different kinds of fields can apply. Are there questions about NIW? Let me just scroll all the way down to the questions. Okay. Let's see. F2 visa, I think we have about 10 minutes left. So somebody asks about H1B to EB5. Yes, you can do that, but EB5 is a pathway to green card. It's not a work visa. So you can start an EB5 process, but you cannot work on an EB5. EB5 is a pathway to green card. So they run parallel. The H1B is a non-immigrant temporary visa, and the EB5 is a green card. So you do still need work authorization and status in the US. And you can change to a B if you definitely know you want to invest in an EB5 program. If your priority date is current, and I believe, I actually have the visa bulletin up here. There we go. So if you're going to invest in a regional center, it's all current. You see down at the bottom, 5th preference. So if you decide you want to, research some regional centers or have your own, business that you invest in, unfortunately on an H1B, you can't put in $1 million into your own business in a rural area. But you can in a regional center, because you can't direct that business. If you, so it's, you can on an E2 or an O1, but, or an L, but not on a H1B, unfortunately. So, but I was going to say that for the EB5, you can file a green card concurrently with the I-140 EB5 petition. So to answer your question, you can certainly do that and remain in the US, because your status would be green card pending, basically. So somebody asked, if I apply NIW, can I reside in the US and wait for approval? Possibly. Again, here's the visa bulletin. You have to look. If you are Indian, country of birth is India, and NIW is second preference. Okay, so here it is, October 8th, 2011. So if your priority date is, prior to that or that date, then you can concurrently file. If you are from Singapore, let's just say, in your EB2 NIW, there's a wait to file that green card of 3 to 4 months, because it says November 2022. But what is the benefit of doing that is you lock in your priority date, and it's not dependent on same or similar, a future job offer. So that's something valuable, I think. I don't think you can reside in the US, no, unless you file for a green card. You need underlying status like a H or L or something. Yes, so somebody asks, if the change of status is filed within 60 days of marrying a US citizen, can we stay after the grace period? Yes. It's filed within. So I don't even think you need that change of status. Like, you could potentially just file for the green card, even after the 60 days. I think you should schedule a consultation. But I don't necessarily think you need that change of status. Okay. Somebody asked, bachelor's and 5 years experience with startup plan, does this count for NIW? It should. I would have to look at your resume, but I think so. Compelling circumstances, 1 year EAD. I don't have a slide on that because I don't think it's a viable option. It's certainly not plan A. Maybe it's plan D or E, and you need to pursue concurrent plans. You need to consider maybe working at a university. They're hiring, like you might have to relocate out of the Bay Area or Seattle. You might have to go to a different industry because it seems like it's tech is where that's suffering, or online or anything tech related, maybe oil and gas, maybe academia, maybe a small startup. So, compelling circumstances when you're EAD, like the example that I read was that the company had a scientist who was at the end of their H-1B, and the company was doing critical research, and the company would suffer. They would lose their grant if the principal scientist didn't get the EAD. So the compelling circumstances in this situation is actually, about the company. But other compelling circumstances could be loss of health insurance of a US citizen child who needs a major surgery, like a heart surgery or something. Like, those are the unique, unusual facts. So I don't think thousands of people who are laid off are going to all, be given compelling circumstances because they were terminated. I don't think that will happen. Let's see. Can we talk about F2 visa? Any concerns? Like, I mean, you can switch to an F2. That's do you have, if you have a very specific question about a concern, I can try to answer it. I think I've already, Rajat, answered the 180-day clock. I don't think it's relevant for F2s. You can file that change of status to an F2. Obviously, you don't have work authorization. You cannot travel. I think I've answered. I'm just going to scroll down. Okay, so let me answer the EB5 questions. Okay, so for EB5, what would be the minimum investment to start the process? Gauri is asking, and should that money be coming from outside the US? It has to come from a legitimate source of funds. That is a requirement. I mean, and what is legitimate source of funds? Like, it can't be like, you can't have like a smuggling operation, and that's, you can't be selling firearms. Like, those are not considered, illegal firearms. So yeah, it can come from anywhere. It can be a loan, a gift, excuse me, from a parent, from somebody else. We have to document that, absolutely. And so here are the minimum investments. You have to look at this column after March 2022. So the regional centers, you have to invest 800,000 unless you want to start your own business of some kind. You do have to create jobs in the US. You have to hire 10 US workers, and I think you need to pay them for several months before we file that case. I've done both EB5 individual petitions for your own company and regional centers. So there are a lot of approved regional centers. I got this number from USCIS website. They have a link. If you don't want to go through, do the due diligence yourself, then you do need to speak with someone. So let's see, what other questions do we have about regional or EB5s? Okay, I'm gonna just go see if there's any other questions. Okay, so there is a last question about EB1A. Somebody asked, they're currently on an H-1B and able to submit my EB1A case. If I do that and get my I-140 approval before grace period ends, can I stay in the US legally? So it's a parallel process, the pursuing the green card and then maintaining your non-immigrant status, your work visa status. Those are parallel. So getting an I-140 approved based on EB1A doesn't give you status. If you have that I-140 approved, you can extend your H-1B for an additional 3 years, but you still need a job offer. Now, if your priority date is current, like if your EB1A is approved and you are attempting to transfer an earlier priority date, from 5 years ago from your old company, and you are Indian, look at this. The EB1 priority date is February 2022, so that's 1 year. So if your 1 year wait, excuse me. So if your priority date is 2017, then you can concurrently file the green card application and then you can stay. But if your priority date isn't current, then you need an underlying status. You need H-1B, O-1, et cetera, et cetera. Okay. Tax payment exception. I don't know that. All right, it's 6:29. So we did good, I think. I'm just gonna make sure we have okay. So this is my email, this is my website. In the chat, in the very top of the chat, if you scroll all the way up, I did put my my calendar. So if you just go to my website, dougallaw.com, then there's a calendar on there. I have a reduced fee for one-on-one consultations. So if you have a unique situation, I recommend you please do schedule that. So Nicole has asked about NIW. NIW is EB2. Okay, so it's just like a perm EB2. So NIW wait time for green card, same as others. It's EB2 wait time, whatever that priority date is on that visa bulletin. Okay. So thank you so much. Thank you again to Albert. I'm gonna hand it over to Albert now.
Okay, cool. I know we have like a ton of questions. Did you want to still answer those, Ashma? I have a little bit.
I don't mind at all.
Let's do it then.
If you're...
I'm gonna go ahead and end Facebook Live, and so if folks want to come on Zoom from there, they can. In the meantime, though, we're gonna stop our live stream. But yes, for everyone who has watched, thank you so much for watching us live, and we'll remain here to answer some more questions. And we'll also have a recording of this video on our YouTube channel, and we look forward to seeing you again soon. In fact, we'll be running this webinar again on February the 16th. So if you didn't get your questions answered or have other additional questions that come up during that time, feel free to join us again, and I'll be sending a follow-up message. Thank you all. I'm going to go ahead and stop the live stream.